Good morning, friends. Today I would like to share my views on the subject, the recent President of India's 14-point presidential reference to the Honorable Supreme Court on the judgment State of Tamil Nadu versus Tamil Nadu Governor case. On April 8, 2025, the Supreme Court delivered a landmark judgment in State of Tamil Nadu versus Governor of Tamil Nadu, holding the governor's inaction was illegal and unconstitutional. This judgment reinforced the constitutional object of reinforcing the principles of federalism and democratic accountability. The judgment was hailed as a historic one by legal experts, democratic and constitutional forces. But it caused heartburn to the fascist, communal, and majoritarian forces who are bent upon to subvert and dilute the constitutional democratic ethos and establish an autocratic, power-centric rule in place of parliamentary democracy and a federal system, in which the elected state governments have authority in governing their states and enact laws in the state subject as enshrined in the Constitution. The ruling really is a milestone in reinforcing the supremacy of the Constitution, the federal spirit and structure, ensuring the constitutional authorities act within their limits by not abusing their power, by setting clear timelines for giving assent to the enactment made by the elected state governments and expanding judicial oversight. The judgment was aimed at preventing the central government from overreaching or misusing the office of the governor and upholding the sanctity of the legislative process. The top court clarified the scope of Article 200 on governor powers and held that governor must exercise the options under Article 200 promptly and could not indefinitely withhold the assent without taking any action, which is called a pocket veto, and held that the said inaction is unconstitutional and clearly undermines the legislative process. And the significant aspect of the judgment is that to prevent undue or indefinite delay, the court prescribed specific timelines for governors' actions under Article 200, stating that number one, withholding the consent or reserving the bill for President's consideration must be done within 1 month, or return the bill to the legislature for reconsideration within 3 months. And third, the grant assent to the repassed bill within 1 month after it presented again. The court here invoked its powers under Article 142, which is most significant one, that is deemed assent, and held that all the bills which are withheld by the governor are deemed to have been received assent and thereby became law, and ensured that the legislative process was not stalled due to the executive or the central government intervention or government inaction for political or other reasons or motives in tune with the dictates of the central government. Governor and court expanded the scope of judicial review. By holding that neither the governor nor the president enjoys immunity from judicial scrutiny under Article 200 and 201 of the Constitution, ensuring that any constitutional authority, that is governor or the president, is held accountable for their actions, duties under the Constitution of India. The central government reaction is on expected lines to this particular judgment, State of Tamil Nadu versus Tamil Nadu Governor. As things stands today, going by the trend of the governance of Modi team at the center, this judgment naturally upset their intended designs of undermining the federal spirit and to exercise unbridled power over the state governments, and particularly in opposition party ruled states. This led to the calculated move of presidential reference to challenge or to reinterpret the Supreme Court judgment by delaying its enforcement and practical application pending the advisory opinion on this reference. Majority people view that this reference is with the ulterior motive of undermining the court directive and in the process to dilute it in some way or the other by buying time. Majority constitutional experts and legal community perceives this presidential reference as a tactic to circumvent the judgment and delay its implementation. Of course, under Article 143 of the Constitution, reference is constitutionally permissible. But its timing, especially when the whole nation is grappled with the aftermath of Pahalgam terror attack and the government being busy in tackling the issue and the contest in which the reference was made, have led to many to view it as a strategic move to maintain central government dominance over the state legislative process, more particularly of opposition ruled states, and the situation created by this reference underscores the tensions between the judiciary in upholding the constitutional mandates and the executive or central government's actions and intentions that may challenge the balance of federalism in India. As a consequence, President Draupadi Murmu has submitted a 14-point presidential reference under Article 143, Subclass 1 of the Constitution, seeking the clarity on the Supreme Court authority to set deadlines for the President and Governor to act on the state legislation regarding the power of Governor under Article 200, raising questions whether Governor is bound by the advice of the Council of Ministers. Can Governor's discretionary action under Article 200 be subjected to judicial review? Thus, Article 361 provides immunity to the President and Governor, bar judicial review of their action under Article 200. Can courts impose deadlines for action under Article 200? Is President discretion under Article 201 subjected to judicial scrutiny? And can courts impose timeline on the President? Can courts review the contents of a bill before it becomes law? Can the Supreme Court power under Article 142 override or substitute the constitutional function of the President or the Governor? Does the state legislative bill becomes law without Governor assent? That is deemed assent order as passed by the Honorable Supreme Court. Thus, the Article 142 allow the Supreme Court to issue orders that contradict the existing constitutional or legal provisions. Is it not necessary that the questions involving substantial constitutional interpretation be decided by a bench of at least 5 judges? And is Article 131 the sole constitutional provision for resolving the disputes between the union and the state governments, etc.? These are the 14 points reference made by the Honorable President Draupadi Murmu. The center is well aware of the fact that the Supreme Court's advisory opinion under Article 143 is not binding. And yet, instead of availing the remedy of review, using presidential reference as a tool speaks volumes about its motives. Senior Advocate Kapil Sibal rightly said that if you do not like the Supreme Court judgment, it's a judgment on final. You must seek a review. If review gets dismissed, you file a curative petition. This is the only way to set aside the Supreme Court judgment. Instead, seeking a reference is nothing but bypassing the legal process available to them. Of course, there is a slight contra opinion by former Supreme Court Judge Honorable Justice Sanjay Kishan Kaul by expressing reservation to the President and other state governors who are not part of the litigation in state of Tamil Nadu versus Tamil Nadu governor case. But he opined that the opinion from the Supreme Court was good enough as it would end further conflicts. What else could have been done here other than seeking a reference, unless another bench of 2 or 3 judges of the court would say the issue needed to be looked into by a larger bench? But Kapil Sibal's assertion that if there is no time frame, they could sit on the bills for months with intention of destabilizing the elected governments and the governors, as the experience shows, that the governors have been interfering in the administration of non-BJP ruled states after the present government came to power at the center holds ground and justifies the reality which was reflected in the direction of the Honorable Supreme Court of India. The leading English daily, The Hindu, in its editorial dated 17/5/2025, rightly opined, by choosing unusual path of a presidential reference, the center is signaling an intent to seek powers to be exercised through the governors that the makers of the constitution had not given to it. The court judgment provided a sound framework for consensus on the role of the governor. The center should accept that, and if at all required, convening a meeting of all chief ministers and political parties to resolve any other residual issues. However, in the present prevailing situation, the political climate, and the way Modi government functions, it is a remote possibility of following the same editorial advice given by the Hindu. In fact, this deliberate move by the center underscores a potential constitutional conflict between the executive and judicial branches concerning the roles and responsibilities in the legislative process. The popular legal website LiveLaw highlighted the center's contention that the concept of deemed consent propounded by the judgment is alien to the constitutional scheme. Further, it also elaborated discuss about the Article 143, under which the President can seek the top court opinion on the question of law and facts of public importance, and pointed out that the Supreme Court is not bound to give an opinion on presidential reference. The court may refuse to express its advisory opinion if it is satisfied that it should not express its opinion, having regard to the nature of the questions forwarded to it and having regard to the other relevant facts and circumstances, but it must indicate its reasons. It is a fact that the opinion given under Article 143 is not binding, but it carries a lot of weight and persuasive value as held by the Apex Court as reported in the judgment 1974-1 SCC 717, and only the decisions given in contested cases are binding. So it is well established in law that a judgment or a decision given by the Apex Court can be reviewed only under Article 137, read with Rules of Order 40 of Supreme Court Rules 1966, and on the conditions mentioned therein. In the Kaveri reference case, the Supreme Court held that if the executive has power to ask the court to revise its decision, if such power is given or is read in Article 143, it would be a serious inroad into the independence of judiciary. The court reasoned validly. Thus, Article 143 cannot be used to refer a question which was already settled and decided by the Supreme Court. That is why the present presidential reference is politically motivated to challenge the independence of judiciary. That is the majority opinion of the legal fraternity. The article reasoned that the present reference could be perceived as an attempt to seek review of the Tamil Nadu governor case in disguise, and response of the Supreme Court will be an interesting and legal and constitutional development to watch out for. In view of the above discussion, the Tamil Nadu Chief Minister Stalin rightly dubbed the move of presidential reference an attempt to subvert the constitutional position settled by the Supreme Court in state of Tamil Nadu versus Governor of Tamil Nadu. He also took initiative and wrote to all the chief ministers of the opposition ruled states to evolve a coordinated legal strategy before court and present a united front to pressure and protect the basic structure of the Constitution as upheld by the Apex Court in its historic judgment. He reminded them that the BJP-ruled union government is attempting to unsettle the judgment which can be invoked as a precedent by other states when faced with the obstinate governor, and pointed out that the judgment obtained by his government was for all the states since it upheld the federal structure and distribution of powers effectively preventing the obstruction of legislation enacted by the state by the governor and urged them to oppose presidential reference sought by the president. The notable question in 14-point reference raised by the president is that whether a 3-month timeline could be imposed through a judicial order when the constitution did not prescribe it under Article 201. But it seems that the government overlooked the fact that the Supreme Court merely adopted the guidelines issued by the Ministry of Home Affairs through two back to office memorandums issued in 2016 by specifically mentioning it in the judgment as reported in the Hindu on 17/5/2025. Thus, viewed from any angle, the move of the center in seeking presidential reference on this Tamil Nadu governor judgment case is clearly motivated strategic move to halt the implementation of the verdict under the pretext of pendency of advisory opinion from the apex court, knowing well that if review of the judgment is sought, it is highly unlikely to succeed as the apex court has dealt with the subject exhaustively and gave judgment with sound factual legal reasoning. At least now, at this stage, let us hope that the Modi government stops this kind of partisan, politically motivated moves which disturb and destabilize the federal spirit and the basic structure of the constitution. So also, the opposition parties, the civil society must stand united by the Tamil Nadu government case judgment and thwart any move to change it, which will have serious ramifications affecting the very roots of parliamentary democracy, federal spirit, and basic structure of the constitution, ultimately harming the unity and integrity of the nation. I hope, my friends, you appreciate my presentation and pass your comments and support this judgment in all possible ways. Thank you. I am yours, Y.Jayaraju Sr.Adv, High Court of AP and President, National Lawyers Forum for Social Justice. Thank you.